Well, I know you're keeping an eye on the time. It's 7:15 this Monday morning. Good to have you with us on eNCA. It's a big court case. The corruption trial of former President Jacob Zuma is back in the Pietermaritzburg High Court today. Now, to remind you where we are currently, Presiding Judge Piet Koen will announce his decision on whether or not to recuse himself. The background to this, it relates to remarks made when he dismissed Zuma's application to remove prosecutor Billy Downer. In the meantime, now what's happened is the former president has launched a private prosecution against Downer. That trial is set to begin next month. So you have to ask the question, how is the judge going to weigh up whether or not to recuse himself in a case like this? What could the prosecution or defense have put forward as to their reasons for or against it? And could these two cases actually impact each other from a legal perspective? Well, let's hear from legal expert Mpumelelo Zikalala joining us this morning. We'll have live coverage as well, by the way, here on eNCA a little bit later. Mpumelelo from Zikalala Attorneys joining us. Morning, Mpumelelo. So let's just take a step back and just understand that as far as I remember things, you have to go back to October last year, the judge himself suggested he may have to recuse himself. This wasn't a request from either prosecution or defense. Was that unusual to your memory?
It was a bit unusual, but it's not a step that you can consider as being irregular. Let's remember, it's only the judge that can decide that, I have certain information within me or certain pronouncement that I have made that when this matter is looked on by the third party, they may then come back and say, but, Judge, you may have prejudged this particular matter. You may have made certain conclusion which leads to the innocence or guilt of the accused, which is in front of you, without any evidence having been led. With that being said, it's clear that you already were biased towards the state, or you already biased towards the accused in this matter. You are not fit and proper to be able to sit and be able to listen to the arguments which are going to be leveled against you. So on that basis, you shouldn't have listened to this matter in the first place. That's where the irregularity is going to sit. And part of it may lead to the accused person being let go or being freed. So it was under this background, or at the back of this background, in which I think Judge Koen then says, I think this is a matter that needs to be explored, if not indirectly, formally, as I'm doing now. I'm going to look into the facts of this matter, look into the nature of my judgment, and come back to a conclusion whether I should continue being the presiding officer or not.
I suppose this could open up a legal can of worms, because now that the judge has asked for submissions from both the prosecution and the defense, and depending what each of them have said, if the judge makes a decision today, which he has to make, and one of the two sides don't agree with it, he's opened himself up. He's opened this conversation up, and now we're going to start this merry-go-round of delay after delay after delay, aren't we?
That can only start if there's one of the parties that says, Judge, we think you are going to be biased, can you please recuse yourself? And the judge says no. On that basis, that matter could go on appeal, even up to the Koen Court, and the Koen Court will have to decide whether those particular grounds of appeal or of recusals are one that should be able to stand or should be able to pass. If the answer is no, then the matter will continue. However, if both parties say we did not make any submissions, or we are of the view that you are fit and proper to be able to sit, or if it's the judge himself that says that I cannot sit in this particular matter, you cannot take that particular decision of appeal, because the court is going to come back as the presiding officer that says, I have intimate knowledge and information that could taint the innocence or the manner in which I'm going to adjudicate this matter on. On that basis, I'm not fit and proper to sit. Get another presiding officer who will be able to sit in this matter. And it's quite in the right case, or the right time, or the correct time in which the president should recuse themselves, because there's no evidence that has been led. So the first witness has not gone into the witness boxes yet. So it is the correct time for a new judge to come in, if the new judge is going to come in at the end of the day.
For Judge Piet Koen, in a case like this, when he's considering a recusal, has asked for those submissions from both defense and prosecution, who would be sitting with Judge Koen when he's deliberating over this? Would he have a panel of other judges? Would he be going to other senior judges? Would he be going to the Chief Justice, for example? Or would he be sitting in chambers by himself, do you think, and mulling this over? Where's the checks and balances on this?
It's with him. Let's remember that he has to do the introspection of saying, what information do I know? What pronouncements have I made? I'm coming up to the conclusion of drafting the earlier judgment. What did I look at? Did I, in my exercise of doing that, come to any conclusions that I could have arrived at without evidence being led to me? do I then think that my mind has been tainted either to think that the person who's in front of me is innocent or guilty? Am I still going to be persuaded by evidence that will be submitted to me? But most importantly, let's look at the judgment that I've penned out. It's out there in the public. So if I'm going to say anything which is contrary to that, or I've made certain pronouncement in that particular judgment, that definitely means the element of biasness may be there. If that matter could be taken on review, on appeal, that the chance of success could be high because it is written in black and white that this is what you said, Judge, and these were your opinions. But most importantly, let's look at the part of the judgment that you're arriving at. There are certain parts in which we call the obiter in a judgment where the court will provide certain sort of advice, and I'll use it in a very loosely manner, or certain pronouncements pertaining to how things should be interpreted and how the law should be interpreted. If that has been taken, mixed together with the facts of this particular case, and the conclusion is arrived at, it's a clear-cut case of biasness that a person could then take through in the later stages and say, but Judge, this is what you wrote. Already when you arrived in this courtroom, before the first witness got into the witness box, you already made up your mind. Now, here it is in black and white in which you are pronouncing indirectly that the accused is indeed guilty. So on what basis do you say you're not biased in this particular matter? But I think for Judge Koen, he's saying this is a very important case, and he laments that particular point. And he says, I wouldn't want to taint it in any particular manner. I want this matter to be adjudicated in a proper manner. And if it means that I have to recuse myself, and a fresh judge will have to come in that will be able to look and see these particular facts, let's do that, because it's in the interest of justice that this process is not tainted at all. This interest is not marred by any instances that could be later challenged by either of the parties. So to eliminate that process, let me recuse myself at this stage so that they can be able to continue.
It's almost in a way of ensuring from the judge himself that there's no impropriety and not bringing the court into disrepute. So if, for example, again, we're waiting for the judge to make his decision and pronounce on that, what then happens with the next judge? Because the next judge coming in, if it were to happen, with no doubt is going to be questioned and asked as well about his potential bias. Who then handles the decision on who the next judge would be? How does that work in a court?
That's the job of the Judge President. She's the newly elected the Judge President of the KwaZulu-Natal Division. Her job is simply on a daily basis to appoint presiding officers who are going to preside over matters. That's what she does on a daily basis. It shouldn't be a problem for her. She simply looks at it from a perspective of administration, the level of experience of the judge that is there. And the KZN Division is blessed with the high caliber of judges who are very skilled, that have dealt with a number of cases, and it wouldn't be the first time in which any sitting judge within the KZN division will deal with such an important matter. So that's purely an administrative matter. Someone will arrive on that desk tomorrow and they will say, you have now been allocated in this matter. Can you please take over it? These are the new dates that have been allocated. So when you go to court on that, the next occasion, this is the person who's going to be sitting in front of you. Now, if there are any applications or allegations of biasness, any other party that alleges must be able to prove, and they'll have to make that application in front of the new presiding officer. So on that one, it's clear cut. It's a quick process. There are no that can take place. It's just purely administrative matters.
And very briefly, Mpumelelo, I can't help but ask you this question just as quickly as you can. Do you think Judge Piet Koen should recuse himself based on those comments?
Not at all. I think he's a highly experienced judge. He has done this now a number of times, and I think he can be able to separate any effects or any other intrusions and make sure that he's able to take a decision which is beyond approach. But for now, I do not think that he should. I was quite surprised, by the way, that in fact he's the one that raised it, but it also explains his meticulousness and in how seriously he takes this particular matter. For me, he has done well up until now. He has done the job of a presiding officer, and I think it's fit and proper to be able to continue with this matter.
And I appreciate your time. I'm sure we'll speak again. Very thankful to Mpumelelo Zikalala from Zikalala Attorneys joining us this morning.